the agenda and related materials. And I will begin by having subcommittee members just introduce themselves in the event we have members of the public who are watching. And I'm just going to go in the order that I see people on my screen, starting with Senator Justin Chenette.
Thank you, Representative. I'm Justin Chenette, and I represent the members of the public.
Thank you. And next, Amy Beveridge.
Hi, I'm Amy Beveridge. I represent the Maine Association of Broadcasters.
Thank you. Linda Cohen.
I'm Linda Cohen. I represent the local government sector.
Thank you and welcome. Christopher Parr.
Hi, I'm Chris Parr. I represent law enforcement interests.
Thank you. Julie Finn.
Hello, my name is Julie Finn and I represent the Maine Judicial Branch.
Thank you, Julie. Welcome. Eric Stout.
I'm Eric Stout. I don't represent anyone in particular, but I'm the appointed member with background in information technology.
Thank you, Eric. And my co-chair of Judiciary Committee, Senator Ann Carney.
Hi, everyone. I will fix the issues in a moment. It's nice to see you all.
Thank you. You sound like you're the Almighty up in a celestial location. And good morning. My name is Tom Harnett. I chair the Right to Know Advisory Committee, and I try to chair this subcommittee as well. And I know we have other members of the public who will be joining us, but I'd also like to recognize our staff from OPLA that is here today, Peggy Reinsch and Colleen McCarthy. And as always, thank them for all of the work they do in getting us ready to have a productive meeting. The first item on the agenda after introductions is a remote meeting policy before the policy is adopted. Brenda Kelsey, the ombudsman on right to know matters in the Attorney General's office, has circulated a proposed draft, and I will turn it over to Brenda if she would like to explain her thinking, or to Peggy if that's the most appropriate thing to do.
Thank you, Tom. I'm actually going to pass it over to Peggy because she drafted the language, which I think is very good, but she may have more information about that than I do.
Thank you, Brenda.
I don't have more information, but Brenda and I talked for a long time after the last meeting and to try to put some language together. And so I put this language together, and then Brenda and I reviewed it, and we thought it was a good starting point. And Linda's already pointed out a typo in paragraph A, subparagraph 1, but we can get to that. So the purpose of this is to provide in statute the ability of a board that is subject to Freedom of Access Act to have an emergency meeting when they can't meet when they would meet all the other requirements about it not being practicable to meet in person, that they would have, but they haven't actually adopted a policy that allows for remote participation, that they could do this meeting. The chair would identify that an emergency situation exists, could call the meeting, to give notice of the meeting, and once the meeting is convened remotely, it's a completely remote meeting, the members would vote on whether to support the chair's determination that the emergency exists that would prevent the public body from meeting in public. So that's what subparagraph 1 says. And then subparagraph 2 says, if the members say, yes, we do agree that this is an emergency situation and that's why we're meeting remotely, we agree with the chair, then they can go on to vote to adopt a policy that allows remote participation. And that policy would have to meet the requirements of the statute. So it's kind of that catch-22 where a body wants to meet, they meet all the requirements of meeting remotely, but they haven't actually gone through the process of adopting a policy. And I think that this is one of the situations that Brenda had identified that was problematic. And I I think there were some municipalities that had run into that problem as well. I don't know, I'm not saying that this is final language, but this is at least a place to start.
Thank you, Peggy. And in essence, this is really trying to address the fact that we find ourselves in an emergency situation based on what's going on with COVID right now. And that can change over time, but it will allow bodies to address that by adopting something without having to have a full-blown public meeting at a fixed location. Do I have that pretty much right?
That's correct. There still has to be the notice and the opportunity for public comment.
Okay. So it's still a very transparent process. It's just the platform on which it is conducted. Are there questions from subcommittee members for Peggy or comments regarding the proposal in general? And if you could raise your physical hands, that might be the easiest way for me to see folks. Linda.
Thank you, Tom. I read this through when I received it. I think it's great. And, I think that it's interesting, or maybe ironic, that this committee is one of the first ones to experience the problem of not having had a remote policy in place and having to meet in public during a pandemic in order to pass the policy. So, we speak from our own personal knowledge, and I think that that's a good thing. And unless anyone can see any issues with this that I'm missing, I think that this serves the purpose.
Thank you, Linda. Are there other comments from committee members? Amy Beveridge.
I think that this is very good. I just want to be sure that I understand this is truly only when there is some sort of an emergency reason. This isn't something that can be a policy of remote meetings, generally speaking. And then the other thing is, I just wasn't sure if there should be something in there about the quorum needs. But I guess if it's an emergency, that's and everybody is remote, that's not the case. But I know I was thinking about in our own case for our full committee meetings where we try to have a quorum in person. So I just wanted to bring that up and see if that was something that needs to be considered at all.
Okay. Thank you. Is that an issue, Peggy, in your mind? I think we're still looking at the default is we want meetings to occur at physical locations, but this recognizes that we need a process for remote participation, but there may be times that you just cannot physically meet to adopt such a policy.
Right. And the quorum issue that you ran into was because you needed a quorum in person in order to adopt your policy. You had to have an in-person meeting. Once you have the policy, if you follow the statute, and you're supposed to follow the statute, then people who are appropriately meeting from a remote place do count as part of the quorum. So I'm thinking that it's kind of implicit that you can't adopt a policy unless you have a quorum. But if you want to specifically address that, we can say that in two in particular, that if there's a quorum, then it's actually a meeting. I mean, if you don't have a quorum, it's not a legitimate meeting, I think.
Right, but that the quorum can be
remote, can be
with remote participants. Okay, yeah, I think to address that concern, it might be nice to have some clarity, additional clarity in the language. Julie.
Yeah, I had a comment that I think is also probably falls under the heading of clarity. In the subsection 1, where it says the chair must give notice of the meeting. I was wondering first if it shouldn't say the chair must give public notice of the meeting, and then also maybe add something like, and provide opportunity for the public to participate remotely. just to include the public in those aspects as well.
Thank you. Is that a doable fix, Peggy?
Well, I understand exactly what Julie's saying about making sure it's public notice, but under the Freedom of Access Law, notice is defined in section 406 about the kind of notice for a meeting. So it wouldn't be just notice to the members, it would be public notice.
Okay.
But that makes sense about making sure, I mean, we talk about notice and hearing, but it doesn't, you're right, it doesn't say anything about an opportunity for the public to participate. So that makes sense to clarify that that has to be a requirement. I mean, that's kind of the whole idea why these entities adopt policies, is to let the public weigh in and say, yes, this is a good idea, or no, this is not a good idea. We don't want you to meet remotely. So that makes sense to make sure that that happens, especially when you don't have an in-person meeting.
Okay, thank you, Peggy. Are there additional questions or comments? Christopher.
Thanks. Can you just remind me, I was looking for, I can't seem to find it. Is emergency, is what is considered an emergency defined in that? Okay, so is it sort of at the determination of whoever's chairing a meeting or what have you?
Well, so yes, generally for this section of the statute, for these particular subparagraphs, the chair says this is an emergency. And when the meeting's there, if all the members agree, then they can go on to adopt the policy. If the members say, no, you're just trying to shortcut things, I mean, at that point, it's a group decision about whether an emergency exists. Does that answer your question?
It does. And would it be like a requirement that everyone agree, or is it just the majority of the, like, I'm just kind of more curious than anything else. Is it require, even if one person thinks it's not an emergency, then you can't do it?
It doesn't specifically say that.
Okay.
And I don't know if you want to require a unanimous vote on that.
Yeah,
I think unanimity would be problematic to have
agree.
that. I think it's a decision that's made by the body in the normal course of the way they make decisions.
Yeah, I agree.
All the time. Okay. Justin.
Thank you, Representative. So later in the policy, we talk about like the existence of an emergency or urgent issue, but in the new language, we're just referencing whether or not it's an emergency or the chair deems it as an emergency. So I just want to make sure that there's consistency throughout the entire statute, that if is it just emergency, or does it include urgent issue? It seems like there's two variables there. Yeah.
Good point.
Senator Carney. I'm sorry. Do you've got that, Peggy? Senator Carney.
Thinking back on the original legislation and to respond to Justin's concern, I think that the inclusion in the inclusion of the urgent issue pertained to, for example, if a bridge got washed out and Board of Selectmen needed to meet on that particular issue on very short notice to do something about it. And so I think that's why we had the urgent issue, as opposed to this is an emergency meeting simply to adopt the broader policy. So I'm not sure that inclusion is necessary in this particular provision.
Does that address your concern, Justin?
Well, I'm trying to play, and that makes total sense, Senator. I'm trying to play out a scenario where there might be an urgent issue for the chair to call a remote meeting. And so it seems like even under your scenario, there could be a situation where that's not necessarily emergency, in quotations, emergency, but it could be an urgent issue where the chair would need to call a meeting if a policy is in existence. I just feel like there should be consistent language if we're going to stick, and I agree with you. To me, it should be even broader, but let's stick with this. Emergency and urgent issue should also be carried over into if you don't have a policy, having it a little bit more wiggle room for the chair makes a lot of sense. And again, our hip check here is that the members have to vote. Maybe if they don't deem it an emergency or urgent issue, and we walk away. So it seems like we still have a, sort of a check and balance in the system.
So I'm hearing people saying two different things. I hear Senator Carney being comfortable with the language as it is drafted, that it's an emergency, which I think perhaps by definition could include an urgent matter, which would create an emergency, but Justin wanting the language to mirror other parts of the statute. Am I missing something, Senator Carney, or do you think we're being redundant by?
I guess I don't have a strong preference. I think that if you're meeting remotely to address an urgent issue, maybe that is the appropriate time to also adopt a remote meeting policy. Personally, my hope would be that public bodies would do this ahead of an urgent issue like that. But I don't see significant. I think it would be fine to include urgent issue if the group believes that's the best way to go.
Okay, but I agree, Senator, that we want bodies to do this sooner rather than later, and not wait till the 11th hour when they have a crisis. Linda.
Thank you. I think consistency doesn't hurt. I agree with the senator. Maybe an emergency covers an urgent issue, but I'm thinking of some urgent issues that might not be necessarily an emergency. So the select board chair passes away unexpectedly, and we're in the middle of a pandemic, and the board needs to get together to figure out what they're going to do about it, but they haven't developed a remote policy and passed it yet. And knowing municipal government like I do, things get put off and put off and put off. And so even though we wish that everyone would adopt the remote policy sooner than later, that there are going to be many communities that don't. And so issues will come up. I just think, being consistent is not necessarily a bad thing.
Other views? I think I'm going to recommend, but obviously that this will be a group decision, that the consistency cannot hurt, and adding the urgent matter into the mix might be the cleanest way to go.
I agree. Thanks, everybody.
Thank you, Senator. Any other comments about this proposed draft with changes? In terms of moving forward, Peggy, I guess what I would do, and you let me know if this is appropriate, is I would take, an initial vote of the committee to see if they approve of this, but we would wait for a formal subcommittee vote until the next meeting where we have the final draft language. But assuming that this committee supports it, I will be able to report to the full committee this afternoon that policy approved by the subcommittee is in the process of being finalized. Does that make sense to you, rather than roll call vote?
That's fine, however you want to do it. I just want to, did you want to include the issue that Julie raised about public participation? Or at least public access to the meeting? Well, public participation. 2 says after an opportunity for hearing. So the notice, I think in 1, the chair must give notice of the meeting and include the information about how the public can participate. Did you want that specifically listed in the language?
I think that is just subsumed in the general right to know law that what public notice means, and public notice includes the right to participate.
Okay.
Unless there are strong feelings on the other side from subcommittee members. So with that, unless there is any further discussion, and I'll, Eric?
Yeah, even though the standard language might kind of assume that about participation, we're in a weird time about remote and hybrid and zooming in and all that. So I would favor being more explicit about that, given that this is about the weird time that we're in. So that's my view, even though it might be assumed that in the language that's been there for decades.
Okay, thank you. Senator Carney?
Yeah, I agree. I think this contemplates the initial involvement of the public body with remote meetings. So I think it's important to include that reference.
Okay, I am totally comfortable with that, and I think clarity is always a good thing. It's just a matter of draftsmanship by our capable staff. So if there are no other comments, I'm not going to ask for a motion. I'm just going to ask if we have general approval to direct Peggy to continue down this path and then bring this back as a full policy to the next meeting. All those that support that, if you could just give me a physical thumbs up, that'd be great. And that appears to be unanimous. So thank you, Brenda. Thank you, Peggy, for this. And we will look forward to seeing the final draft at our next subcommittee meeting. Thank you. The next item on the agenda is LD 1772, which is an act to amend the Remote Meeting Law in Maine Freedoms of Access Act. This is a bill that I submitted on behalf of Maine Municipal Association. It was basically drafted by Kate Dufour and was approved by legislature and has been printed and is available online. If you could take a few minutes to address the concern that you heard from municipalities and what you're trying to, what I am trying to accomplish on your behalf with LD 1772.
Well, good morning, everyone. Thank you for this opportunity. When the initial law was enacted, we heard two complaints or two concerns raised by municipal officials across the state, and both have to do with the needed level for clarity. And so what this bill seeks to do is address those two concerns. The first is with respect to the restrictiveness that was built into, I think it's section 2B, with respect to when an emergency exists. Some communities found that the language does provide opportunity for meeting remotely in what they would see as an emergency. Others felt that the language was too restrictive and connected to a statewide emergency. And so what our proposal would do is basically leave the decision or the definition of an emergency and when it's most appropriate to use remote means for the public body to meet to the public body and to the residents of a community who are going to participate in the conversation as to how broad or limited that remote authority is. So that's the first section, first amendment made in this bill. And again, thank you to Representative Harnett for moving it forward. The second concern that we heard is under the existing law, every municipal board or council within the municipality has to adopt an ordinance. So in Hollowell, for example, the council adopted an ordinance, a policy, but so did the planning board. And so what the second amendment in the bill would do is say once the public body has adopted a policy, it pertains to all boards and committees within the municipality's jurisdiction. So in our case, if if this law had been in effect, the council would have adopted the remote meeting policy on behalf of every board, every subcommittee, including our planning board. So those are the two changes being advanced in this legislation.
Thank you. And as to the second one, that was a concern that we heard both in our full committee meeting and in this subcommittee meeting, that there are municipalities that could have dozens of separate bodies, commissions, planning boards, et cetera. This would allow for a blanket rule. Is that correct, Kate?
That is absolutely correct.
Okay. And as I said, this is an LD, will move forward, will be referred, has been referred to the Judiciary Committee. So it really does not require action by this subcommittee, but because this is an area that we are focused on, I do want to let members of the subcommittee to raise any questions they might have or concerns that they might have, knowing that this will go through the typical legislative process of a public hearing and work sessions. It was really more of an FYI for the committee, but for the subcommittee, but I do want to hear from folks if they do have questions or concerns. So I will open it up to committee members. Subcommittee members. Par.
Thank you. And it could be that my coffee's starting to wear off, but could you re-explain the first? I understand the second intent, but what is the first part of the bill trying to do again, Kate?
It leaves all of the decision-making authority in the hands of the board or the council. And so if you look at the existing law, there are 4 provisions that dictate when an emergency or when remote meetings are appropriate. It would leave that decision-making, again, to the board that is adopting the policy. So it provides boards far more discretion to determine when it's most important, for that board to meet remotely.
And Kate, it also allows more discretion about allowing individual members to pick remotely, hybrid, with the position of the chair of the body. Is that correct?
That is correct.
By eliminating those the 4 criteria that were set out in subsection B.
Correct.
And in addition, could allow for a suspension of the physical location being available all the time for members of the public. Right.
That is correct.
You get to your question, Chris?
It did, yeah. And just personally, I think this bill makes a lot of sense. So thank you. I appreciate it.
Okay. Are there other questions, comments, concerns by subcommittee members? Eric?
I just wanted to agree that it's a common sense approach. And I think as long as the local bodies are in good faith, following the principle of being transparent and accountable to the public they serve, then giving them latitude, reasonable latitude to apply their judgment, how to operationalize that, as long as they're following the principles of accountability and transparency. I think it's a common sense, and it doesn't lock people into being overly prescriptive from the central government state level.
Thank you. And remember that the Freedom of Access Act is always to be interpreted to advance those goals, and exceptions are to be interpreted as narrowly as possible. So I think that is built in, but I appreciate that. Other questions or concerns on this, knowing that we will all be at a public hearing about it sometime soon, hopefully, maybe remotely. Seeing none, again, that was more of an FYI to the subcommittee. This will move through the process. The next item on the agenda, item number 4, is remote participation by residents of correctional facilities. This was an issue that I had raised and other members of the Judiciary Committee raised, particularly when we had a bill regarding parole that would impact the lives of members of our community that are incarcerated in typically prisons, not really county jails. And there was no way for them to participate other than through the provision of the submission of written testimony. My goal here was to try to develop a policy that allowed incarcerated individuals to have access to the government process and to be able to participate in the same way as other members of our society. We recognize that there may be concerns amongst those organizations and entities that advocate for victims and survivors. And we put out a request for comments in an informal way. And we heard from Kara Cookson from the Victim Witness Advocate Coordinator, and also Andrea Mancuso from the Maine Coalition to End Domestic Violence. And I don't know if people have had the opportunity to read those comments, but they certainly raise issues of great concern to those organizations and on behalf of the persons that they represent. One of the many times in my life, I realized that things that I think are relatively simple and straightforward can be relatively complicated and not so straightforward. So I want to first hear from members of the subcommittee if you have a reaction to the comments that were submitted. And then I want to open it up to members of the public, both from those entities and also from members of the public that represent perhaps a different interest on this issue. So that was a long-winded way of saying, are there members of the subcommittee who would like to be heard on this issue and the material that was submitted to us? Eric.
So I more had a question, and I agree with the concerns of the victims. I myself and my family have had, traumatic things happen. So, but my question was, are we talking about full-throated participation? I'm thinking of the levels, like this meeting here is available for the public to watch passively on the YouTube. So they have the advantage of being able to see and hear everything, but we can't see them and they can't talk. Then there's the intermediate level where this committee, for example, could allow people to selectively enter the room, turn on their ability to be seen and heard, and then turn off that ability. That's the middle level. Like we had special guests, like the state archivist, for example, last meetings, we could let her in the room and she could speak, but then not everybody from the general public would be open. There's two levels, passive only or selective. And then there's the full participation, like those that we see here that are logged on to the Zoom meeting versus, the public passive YouTube where they can't talk or be seen. And then they can chime in at any time. I don't know if you as a chair or Peggy as the administrator can shut off their mic, if they, but I'm just wondering about, are we only talking about full access participation where they can like kind of Zoom bomb us, or that it would be selective levels of that I just described, either a passive view only or a hybrid invited, but then turn them off and let them in the room and then kick them out of the room, or just open access. Like the two letters seem to be reacting to the last scenario where there would be open full access without any intermediate control. So that was kind of my question as to what was intended and to lay out those three options: passive, view only, or selected, let them in the room momentarily, or full access. So I just wanted to ask that question and lay out those three levels.
My intent, and I'm speaking for me since this was the issue that I raised, was to allow persons who are incarcerated to testify at legislative hearings about bills that might impact them to the same extent as other members of the public. The way that typically works in our committee is individuals are let in one at a time or two at a time to provide oral testimony in addition to their written submission. That is limited typically by a clock, particularly when we have a lot of people who wish to testify. It can be 2 minutes, 3 minutes, 5 minutes. And then they are put back in the waiting room. It's not an opportunity for a back and forth discussion, other than if there are committee members who have questioned the person who presented testimony. So I don't know what level that falls into. Certainly not passive and view only, but it is also not, as you described, full-throated with the back and forth, with the ability of individuals interrupt a meeting. And we've had, our experience with remote meetings in the legislature is really based on the last regular session. And if people abuse that privilege, we shut mics off and remove them from the room. But having said that, I think the comments that we received from Ms. Cookson and Ms. Mancuso raise concerns about that level of participation, that level of even providing testimony. So I don't know if that answers your question, Eric, but that is the best that I can explain the intent that I had here.
Yeah, that's good. Yeah.
And Senator Carney.
Thank you. I was just wondering if because I feel like there's a question that we need to answer before we even get to the level of these considerations, which is the barrier to participation in remote meetings a barrier that is created by the right to know and public access laws, or is it a barrier that exists within the Department of Corrections that we don't really have any influence on? Do you understand where I'm getting to?
I do, and I think that's a perfectly legitimate question, because the Freedom of Access Act itself does not guarantee the right to participate in the legislative process. And I came from this not knowing if this was the correct vehicle to use, but I saw it as an access to government issue. And that's why I thought about possibly using this as the vehicle to do so. But that's not to say that it's the only. And we have not heard from the Department of Corrections on this. And obviously that's something that we would have to hear. There is a meeting, there's a public review, the Criminal Records Review Committee that's been meeting during the off session, has an incarcerated individual who participates in that and participates fully in that process.
Mm-hmm.
So that there is a mechanism I know that DOC has to allow that, but that's one person, one meeting. So yeah, I'm probably not answering your question, but.
No, but I think, so when I read the letters that were submitted to our subcommittee, it made me think about access. And even, so for example, someone who had been impacted by domestic violence maybe wouldn't even have the technological capacity to join a remote meeting and would be forced to submit something in writing because of lack of technological access. And then I started to think about people who are incarcerated? And are they, I'm assuming, and it sounds like from the public records, the criminal records subcommittee or committee, that there's the technological capacity for them to access. And so is the barrier a policy within the Department of Corrections, for example, that we can't really necessarily impact? But I guess, can we reach out to the Department of Corrections and get an answer to that question? I think it would help us determine whether we could move forward or not on this.
I think that is a necessary step. And I know, and I believe, Julie, you raised some questions about this as it related to corrections, or am I misremembering?
I don't recall raising an issue about this, but I could be misremembering. So.
I think that is a step that we have to take in order to move forward, Senator Carney. But I also don't want to stifle discussion about the general issue as we await that information, even if that information will tell us we can't do what it is I want to do, for instance, or I think I want to do, or this subcommittee wants to do. So I would, I guess, like to have some discussion today, knowing that we will make a direct request to the Department of Corrections about just the logistics and feasibility of this, and determine is this us or is this another committee that does this? Is this criminal justice and public safety? I don't know that. Does that sound reasonable?
Yes, I just had one other comment, and I know that Amy
Sure.
Beckridge has her hand up, but just briefly, you had mentioned too about testifying on bills that impact them. And I think that there's such a wide range of bills that we need to look at this as, from a First Amendment perspective, if they're going to have remote access to participate on bills, for example, that involve parole, then I would think that they should also have access to testify on bills that relate to, main care benefits and traffic laws and everything else that we deal with in the legislature.
Right. If they have the right, they have the right to participate all the time, not when we determine.
Exactly.
This makes sense. Okay, thank you. And you said you saw a hand up and I missed it, so I don't know who had a hand up. Amy?
I just had a question about the current situation. Is there, are incarcerated persons allowed currently to at least submit written testimony? And so this is the idea of giving them broader access that the rest of the general public has.
That's correct. And I think in some of the material that was submitted, someone pointed out that more than half of the written testimony on the parole bill was submitted by persons who were incarcerated at the time. But I do know that this was an issue in front of our committee on that bill. I also know that it was an issue for the Criminal Justice and Public Safety Committee, where they wanted to hear from incarcerated persons on a particular matter, and they were unable to do so because the Department of Corrections said they could not make that happen. Does that answer your question, Amy?
Yes, thank you.
Are there other general comments, knowing that it's not going to be a resolution today, but just general comments on the broader issue from members of the subcommittee? Seeing none, I'm told my internet connection is unstable. I hope that does not mean I've been knocked off. I know that we had representatives from the Coalition Against Sexual Assault. Peggy, do we still have those folks here?
I don't know that any of them signed on. I had asked for written comments initially, and then I asked if they had wanted to participate in the meeting. I did not get feedback on that. I had also reached out to Megan Sway and Michael Cabetti to see if the ACLU, nationally was tracking this issue and if they had any information about this happening in other states. And I think that's why Michael's here to comment, as well as kind of to respond to the whole idea about residents of correctional facilities participating. But right now you do not have anybody from the victim, witness, advocate, survivor community signed into the meeting.
Okay, I thought I saw Elizabeth Ward Saxe pop in for at the beginning, but I do not see her on my screen now. And I know that I had asked that question is, are we operating on a whole cloth here, or is this an issue that has been addressed in other jurisdictions?
Right.
My understanding is you guys were not able to find anything right on point. So I'm very interested to hear from Mr. Kebeda about the views of the Civil Liberties Group, the ACLU of Maine. So welcome, Michael.
Thank you, Representative Harnett, Senator Carney, and members of the Right to Know Advisory Commission. We, just like the Office of Policy and Legal Analysis, haven't found any exact precedents for the proposed idea here. But given that Maine is only one of 2 states that allows people to vote from prison, and given that Maine has one of the lowest incarceration rates in the country, we think that it would be a very good idea for Maine to lead in this area. So I'll briefly introduce myself to those who I don't know here. My name is Michael Cabetti, ACLU of Maine Policy Council. And I have some remarks about this idea. We think that the right to participate in the lawmaking process is a pillar of our democratic system. And we strongly recommend that this committee develop a policy that would allow incarcerated people to participate remotely in legislative hearings. The consequences of such a policy would be the enhancement of the First Amendment right of incarcerated people, whose rights to read, write, speak, practice their religion, and communicate with the outside world are often curtailed far beyond what's necessary for institutional security, which is typically the rationale proposed for restricting the constitutional rights of incarcerated persons to strengthen the security of the carceral setting. No such concern exists here. We believe that the ability to participate in the lawmaking process is central to the ability of prisoners to retain their humanity, but also to contribute to the flow of information between prisons and the outside world, and thus provide a vital form of oversight of these closed institutions. As Representative Harnett just mentioned, advocates for victims and survivors have submitted 2 letters raising very important objections to the extension of remote participation into carceral settings. Namely, that testimony by people who've traumatized victims and survivors in the past might re-traumatize those same victims and survivors during legislative hearings, and might even entirely dissuade victims and survivors from taking part in the legislative process. These points are valid, but we believe that the proposed solution of banning prisoners from speaking in the legislative process is too far-reaching. Instead, we suggest the solution of a narrowly tailored committee rule of procedure, which can just as well protect victims and survivors from re-traumatization. It's entirely within the power of committee chairs to restrict testimony from carceral settings to a designated time period, for example, and to warn all participants when testimony from carceral settings is forthcoming. Committee chairs could also allow victims and survivors to speak first before testimony from carceral settings. Rules like this, which could be incorporated into the Right to Know Advisory Commission's recommendation, would allow victims and survivors to simply leave the room or turn off their Zoom screens during the portion of testimony that could be re-traumatizing. But the same rule would protect and advance the constitutional right of the governed to petition their government. To Senator Carney's point about whether this issue should be dealt with in the DOC rather than the Right to Know Advisory Committee, we both agree and disagree. We agree that the DOC should enhance the right of prisoners to participate in legislative hearings, but we believe that any policy developed by this committee would provide much needed encouragement to the DOC to allow the population in its prisons to participate in the lawmaking process. We urge you to develop a policy that would allow people in carceral settings to take part in legislative hearings. And I thank you for listening, and I'm happy to try to answer any questions.
Are there questions from subcommittee members for Mr. Kebeda? Michael, I have one. Are you suggesting that the statutory change is not necessary here, that this might be something that can be dealt with working with committee rules and consultation with the Department of Corrections, knowing that the judiciary is just one committee that might be facing this issue? So I'm curious as to what you think this would look like if it's not a statute.
I think that both a statutory change making clear that incarcerated people have a right to testify in legislative hearings and committee rules to safeguard the rights of victims and survivors would be appropriate. So the objections raised in the letters from Maine Coalition to End Domestic Violence and the Attorney General lawyer, not an official letter from the AG, but from a lawyer from the AG, basically said that allowing this to happen would endanger victims and survivors. And we take that seriously, but think that preventing it from happening is not the right solution. That a committee can easily deal with that issue by restricting when testimony from prisons and jails happens, and warning every person when it's about to happen.
Thank you. And what letter are you referring to from the Attorney General's office?
Let me just pull it up. It's from from Kara Cookson, who is a victim witness advocate coordinator.
Okay.
From the office of the,
Okay, I didn't make the connection with the AG's office. But you're right, that's where they are housed. Okay. Are there questions for Mr. Kebeda from subcommittee members based on his latest statement? Eric.
I just want to emphasize that I think Michael is bringing up a point that we've talked about earlier about how the technology that's been employed largely because of the pandemic over the last couple of years actually gives us opportunities for more flexibility in who can communicate and how, and controls and options about that, as we just mentioned. So just want to kind of emphasize that point, that Michael is picking up that point that he's also making, that because of technology, Zoom or other communications, you can have controls on that we didn't have a couple of years ago. And that can play into decisions about public policy.
Thank you. Senator Carney.
Thank you. I agree with Eric, and I wanted to present sort of a complication that we face here in the legislature, which is, I think, a really important thing to consider, and ask Michael, would you envision this continuing even after the pandemic is over? I know that's an odd thing to say now because it feels like it won't ever be over, but because right now what the legislature can do is we can have hybrid meetings, but only in the AFA room, where we have members of a committee present and then others participating remotely. Or we can have a meeting that is fully remote. And if we try to do meetings that are a hybrid in our regular committee meeting rooms, we get the weird audio effect that we had when I tried to do that an hour ago. And so I guess I'm just thinking, if we create a policy, are we actually creating a policy that would say that committee meetings will have to have that hybrid capacity in the future?
Thank you, Senator Carney. Ideally, yes. I don't think that it would be great to give incarcerated people a right only to take it away once the pandemic, if the pandemic goes away. I think that it would be a maybe steep learning curve and one-time cost to institute the infrastructure necessary to enshrine this capability. But once that happens, I think that it would be a boon to the democratic process for everyone affected by the legislature's enactments to weigh in on them. And that includes incarcerated people.
Thank you, Senator Carney. Michael, just to follow up on that, assuming we ever are back to normal, whatever that is, and we have nothing but in-person meetings, and I have some concerns about losing the access that people had, regular, not incarcerated folks, to participate in the legislative process without having to drive from Caribou to a meeting. But if we went to fully in-person, would the constitutional concerns you have about the rights of incarcerated individuals, could they be satisfied with participation in less than physical presence in the room? Meaning a hybrid model for testimony.
I think so. I mean, this is an area that I don't know of any case law about, but there is a general right to participate in the lawmaking process. But prisoners have very restricted rights because of the security needs of the carceral setting. But to your point about the overall benefits of remote participation, I know people who, as a result of physical disabilities, were working fully remotely for years before the pandemic. And what the pandemic has meant for many people is that now more people live in that world. And it would be really a huge missed opportunity for the legislature not to extend some of the benefits of remote participation into the world after the pandemic.
Thank you. And I realize that's a much larger issue than the one that's right in front of us, but certainly one that we will be considering moving forward, I believe. I do note that we have been joined by Elizabeth Ward Saxe. So if there are no additional questions from subcommittee members for Mr. Kebada, I would, and I'm not seeing any hands up, I would like to welcome Elizabeth Ward Saxe to provide the subcommittee with your thoughts.
Good morning. Thank you so much, Chair Harnett. Elizabeth Ward Saxe, Maine Coalition Against Sexual Assault. As Ms. Reinsch, I think, alluded to, I did not submit written comments on behalf of Coalition and also did not prepare to make any statements this morning, but noting that there were not other victim service providers, I jumped in. So it may be helpful to know, in part of it was the timing in terms of providing comments. Frankly, I was on vacation. But also, I think that there are lots of mixed feelings within our sexual assault victim services community these days. And I just want to kind of share some broad themes. So I want to acknowledge that I think there's broad support for many of the concerns raised by Ms. Mancuso and Ms. Cookson in their written remarks. And I also think that there is some agreement with some of the remarks that Mr. Kadepe provided today as well. I think what we find ourselves thinking a lot about these days is the disproportionate voice of, number one, victims of very, very serious crimes driving a lot of the decision making. And so when we have a conversation like this with your committee, there's an immediate hard, I don't know if it's a left or a right turn, but towards crimes of murder, of gross sexual assault, the highest level of crimes. And the considerations of those crimes, I have noticed, end up driving decisions about a much wider range of offenses and all the things that come out of those offenses, including the individuals who have engaged in those activities. And so I personally struggle with this conversation because, while again, I do agree strongly with the written comments of my victim services colleagues, I also would not want to shut the door on participation by those who are incarcerated, who have an important role to play in some of these decision making. And so I don't know that we could come to a policy that would fully protect victim survivors of the most serious crimes. And I'm not sure that from our perspective, it might look just like turning off the video as was previously suggested, but I think there is a road where folks can participate. We work a lot with folks who are incarcerated, who are victims of prison rape. We work a lot with folks who are incarcerated who have previously been victims of sexual violence. The vast majority of our incarcerated folks who are presented as female have been experienced sexual violence at some point in their life, and it's deeply connected with the crimes that they've committed along the way. And so, those voices are really critical in the decision-making process. So that's me here sounding wishy-washy, which is why you don't have remarks from me, because I need to be less wishy-washy, and I need to have all of my victim service providers behind me, which I do not. And so I would be thrilled to be involved in further conversations with around this, and maybe it's really us and some other victim service providers and ACLU of Maine in a back room having some conversations first before we come back to you. But happy to answer any questions with the caveat that I'm wishy-washy.
Thank you very much. I don't think you were wishy-washy, and certainly this is a very big issue with a host of sub-issues attached to it, and might take more time to resolve than I originally thought, with more discussion by more stakeholders. So I don't want you to think that the fact that we reached out to you while you were on vacation precludes you from being an active participant in this discussion, because it does not, from my perspective. So I guess I will ask if there are questions from subcommittee members for Ms. Ward Saxe about what you've just heard from her, and then I will give some thoughts about how I think we might move forward. Are there any questions from subcommittee members? Seeing none, let me tell you where I am at thought-wise, since this was an issue that I first raised. One, we definitely need to hear from the Department of Corrections about, the practical realities of making this happen, and why decisions were made that it could not happen in the last regular session. This is an issue that remains of great concern to me in terms of the constitutional rights of persons who are incarcerated. But I'm not going to turn a blind eye or deaf ear to the concerns raised by the survivor community. And I think hearing from both Eric Stout and Mr. Kebeda that there are policies that can address a lot of those concerns. And I realize we meet as a full committee 4 times, which our final meeting might be 2 weeks from today. And I'd be foolish to say I think we can resolve this issue in 2 weeks. But I do want to continue this discussion. I do want to hear from the Department of Corrections about the practical side of this, but I also want to have a full discussion amongst everyone who's impacted by this, and I don't want to see it drop. So I'm not exactly sure what that looks like, but I'm sitting here right now, unless I hear others who feel differently, that coming up with a statute on this in the next 2 weeks or before we report out as the Right to Know Advisory Committee presents some significant challenges. So I would like to figure out a way to have folks weigh in, continue this discussion. Maybe it is with a group of stakeholders that doesn't involve the legislature right away. So I feel like I'm rambling a bit, but that's where I am right now. Senator Carney.
I don't think you're rambling, for the record. I think you've given the right list of the steps we need to take. Could we please add to that a conversation with the legislative IT personnel, because that's the other end of the connection that we need to think about, both with regard to people who are incarcerated and with regard to anybody throughout the state who wants to continue to access legislative hearings and work sessions remotely.
I think that's a great idea, because it addresses not just this precise issue, but the larger issue about what the legislative process might look like moving forward for lots of folks who cannot be here. Other comments or thoughts from subcommittee members? Eric?
So I know our last scheduled full meeting, full committee meeting is December 15th, but I'm just wondering whether there might be time to get the input that we would seek from the Department of Corrections about the logistics of, like Zoom meetings and that kind of thing in a secure setting, as well as the idea of how that would play out on the receiving end with the legislative IT folks. Is there time to we've got 2 weeks, I guess, to get that input, and then, not to make more work for you, Tom, but would there be an opportunity to have another subcommittee meeting of remote participation that we can have those inputs, and then that would give us an opportunity to bring it to the full committee? Just a thought before we close out the year session, because I think all are agreed these are important issues to balance.
Thank you, Eric. Peggy, what is our flexibility in terms of meeting, and more importantly, having those meetings staffed by the capable folks at OPLA?
Well, the statute that creates you says that we staff you until the legislature is in session. So the legislature will not reconvene until January
5th,
3rd, 4th, whatever it is. So we could continue, you could still continue to work and meet and have us participate with that, assuming that there's people who are not on vacation available to help you. But also, you are required to meet 4 times. I'm not sure why there's no light on me right now. But anyway, you are required to meet 4 times, but that doesn't mean that's your minimum. You can meet as many times as you want. You were kind of budgeted for 4 in-person meetings, but you can, handle that because the statute says you can meet. I guess if if you identify times that you can meet, and we can try to get the input from the Department of Corrections and legislative information technology, we can try to keep going if you want. Your subcommittee can continue to meet even during the session. We can't guarantee that you have any kind of staff from us, but you know, you can keep going forward working. You could also create a working group to work on this and report back to you, or report back to the Judiciary Committee, or maybe to the Legislative Council. If this is a bigger issue, maybe that's who should be looking at it eventually.
Thank you. Eric.
I guess to be more clear, what I was suggesting is that could we get quick feedback from corrections and legislative IT prior to our December 15th regular meeting, and then have a subcommittee meeting that morning or prior to? Is that too ambitious to try to do that rather than tacking on, you know, an extra meeting? You know, we have 2 weeks between now and then. That's what I was kind of throwing out there.
We can certainly try. And if you want to schedule a meeting, and if we don't get that input by that time, then it could be a very short meeting.
Thank you. My suggestion for discussion is to begin to seek the information, to see what we have in front of us. You know, I would hope we could meet as a subcommittee on the 15th, preferably before our 1 o'clock meeting, our regular 1 o'clock meeting, and then assess where we are. In my heart of hearts, I think that even if we have that information, we still have a lengthy discussion or process that a lot of people need to weigh in on. So I'm not suggesting that we would have, even if we have a full response from IT and DOC by the 15th, if a statutory recommendation from the Right to Know Advisory Committee is something that could occur before, you know, we put out our report to the Judiciary Committee and the full legislature. So I want to keep all options open, I guess. So that is how I would recommend that we proceed, and then perhaps establish a working group, not just this subcommittee, but other persons, stakeholders, to have an ongoing discussion about this issue and the broader issue of remote participation in the legislative process. Does that make sense to folks? I'm not seeing a lot of Senator Carney.
I'm kind of a newbie to the Right to Know Advisory Commission, but could that be one of the recommendations in our final report, that such a working group be formed, convened to look into all aspects of this issue?
I believe that we could. I think that's a wonderful suggestion, assuming it's agreeable to the subcommittee and eventually the full committee. And that's doable, right, Peggy? I saw you nodding your head. Okay. Again, what's important to me is that we do this right, but that we don't drop it, because I do think it's an issue that needs to be addressed. So if people are generally comfortable with that approach, if I could just get a physical thumbs up from subcommittee members, I'd appreciate that. Okay. And Peggy and Colleen, I will sit and talk with you after we're done today or tomorrow about, you know, how to move forward within the next 2 weeks. Make sense? Okay. Thank you. The next item on the agenda is other. Are there any issues that other subcommittee members have that they would like to bring up at this time, or that they would like to have added to our December 15th subcommittee meeting, which will be scheduled within the next 24 hours in terms of time? Other issues? Seeing none, no hands going up, and knowing that our plate is pretty full, I'm comfortable with that. The next item is a future meeting. I would like to suggest that we meet as a subcommittee on December 15th prior to our full meeting. And we will probably do that in the same fashion that we're meeting today, which is fully remote. And seeing no objection, unless anybody else has other matters they would like to discuss or questions that they have, I would entertain, first of all, thank you, everybody, for very good discussion on this topic and others today. I really appreciate everyone's input and insights. Mr. Parr.
First, as one who is a rambler, I can tell you, you are not a rambler. Number one. Number two, I want to thank you for, I thought you did an excellent job coordinating and moderating this meeting. So thank you very much. It was very helpful.
Thank you. With that, I would entertain a motion to adjourn until we meet again on the 15th, and we'll keep everyone up to date on that. A motion made by Chris Parr. Do I have a second? Seconded by Ms. Cohen. Any discussion? All those in favor? Thank you very much. We will see each other in 40 minutes. Take care. Thank you.